So just as a background, at the end of last year, you would all be aware of the fact that there was a certain amount of uproar related to the RAF when the acting CEO, Collins Letsuala, decided to ask panel attorneys to return files with the intention of trying to settle the matters. The response to that, of course, was that the attorneys then applied for an interdict against him, and in the affidavit that he filed in response to this, he made it very, very clear that he planned, one of the ways he planned on dealing with outstanding matters at the RAF was to settle them and particularly mediate them. So, you know, that was great news for us who are in the area of mediation and who advocate for mediation in appropriate circumstances. And at the same time, he approached SAMLA to assist with a pilot project to really try and test mediation on live cases at the fund. Unfortunately, COVID-19 happened, and that was one of the projects that has been delayed while we deal with the virus. But that does give us a sense that mediation will eventually happen at the RAF. We don't know what form that mediation will take, but what is really important is that people who want to be involved in that, whether you want to be involved as a mediator or as a plaintiff attorney, or as a RAF attorney, have to understand how the RAF operates and the context of the RAF. And it is really from that perspective that we today have this webinar. It's to give you insight into how the RAF operates and what the considerations are if you are going to get involved in mediation in that area. So that's just to set the context as to why Conflict Dynamics thinks it's important to be addressing this issue. So just to welcome everyone who obviously has shown an interest in this. We've got a lot of people that are interested, and people I'm sure that will still be joining us today. And then also just welcome to Lee D'Souza and Joshila Desai, who've agreed to come and really inform us on this context today. Lee is one of our mediators, and that's how we've got to know Lee at Conflict Dynamics, because she's an accredited mediator with us. She has years of experience as a plaintiff attorney working on RAF matters, and has taken a particular interest in converting these matters to mediations, which I'm sure she'll speak to later. Joshila is an old colleague of Lee's, and has also spent a lot of time dealing with personal injury matters, but has also worked within the RAF for 5 years. So she understands that institution well and will be able to give us some insight into its operations. So thanks so much, Lee and Joshila, for being here. Also thanks to Craig Holscher, who's managing the logistics, the technology behind this, and will be taking care of our connectivity for the next hour and a half. Lee and Joshila are going to be dealing with a number of issues, and just to give you a sense, Craig, if you'll just put the slide up of what we'll be covering today. They'll be giving us some sense of the background of the RAF, the claim process and what actually is claimable at the RAF, how claims are quantified and the principles of liability. They also deal with the issue of quantum, so you know how that gets determined, and how one can then mediate that, and finally just looking at that whole aspect of mediation and whether it is appropriate for RAF disputes. So Lee and Joshila will be moving between the two of them as they address different aspects of these issues in discussion. I really encourage you to post any questions on the Q&A at the bottom of your screen, or even just use the chat function to raise issues. I'll be keeping an eye on that, and we'll give Lee and Joshilla an hour to deal with the content. If you've got a burning question, just post it and I may interrupt them. But if that doesn't happen, we'll definitely have a good chunk of time at the end of their presentation to address questions and answers. So thank you very much for being here, and over to you, Lee and Joshilla.
I'm going to unmute myself there, Marion, just to say thank you for having us. I'm very pleased to be here. I like to refer to conflict dynamics as my mediator mentors. So it's really a privilege to be with you. As Marion said, we're here to give an overview of the Road Accident Fund, its function, how you can claim, what you can claim for, and what sort of proof is necessary in order to prove the claim against the fund. So I'm going to kick off with having a discussion about what the RAF is. I'm sure many of you know already, but I'm going to just mention it anyway. The Road Accident Fund, they're basically indemnity insurers. It's a state, it's a parastatal. They get their money in the form of a fuel levy. Levy currently sits on, I think, R2.07 a litre. So the Road Accident Fund is governed by legislation, the Road Accident Fund Act. Their executive authority is transport. And basically, they indemnify drivers on our roads who cause collisions, which in turn cause injuries to other parties. You can claim from the Road Accident Fund if you're injured in a collision. If you're a driver, you need to prove that the collision was not your fault and that it was proved by the negligent driving of another motor vehicle. So you cannot base your injuries or the claim or the basis of negligence on anything other than the negligence or other unlawful act of another driver or owner of a motor vehicle collision. And it's quite important because the Road Accident Fund requires that fault in respect of drivers and pedestrians. There used to be limitations on passenger claims. Those limitations have now been moved. So passenger claims are unlimited to the extent covered by the Road Accident Fund Act. You can only claim in respect of personal injuries that are sustained. You cannot claim for damage to your vehicle or damage to anything that was inside the vehicle. It has to be damages arising from injuries that you've sustained. Post 2008, there was a limitation on what one could claim. 2005 Amendment Act came in, and as of 1 September 2008, you have to prove certain things in order to claim certain heads of damages. In addition to that, claims for loss of income are capped, and there is a process that one has to go through in order to prove a general damages claim. Your general damages is basically your pain and suffering award, but we'll discuss it a bit later. So right now, you can claim from the fund, but the extent of the damages claimable are limited. And basically, one runs through a very specific process in order to claim from the Road Accident Fund. So what one has to do is one has to gather a whole lot of documentation. There is a specific statutory report which is required. You have to depose to an affidavit setting out how the collision occurred. You have to submit medical reports and records. Records are not essential for lodgement, but they most certainly do help the Road Accident Fund. And there are a couple of other documents that one collects together in order to submit to the Road Accident Fund. In order to claim, there are two different types of claims from a logistical perspective on the lodgement side. You can claim if you are involved in an accident and the driver of the other vehicle is identified. In those circumstances, you have 3 years within which to claim. If the driver or owner of the vehicle that causes the collision is unidentified, apologies for the dogs barking, if the driver of the vehicle that causes the collision is not identified, you have 2 years in which to claim. And it's quite important to differentiate the two. So the claim will be lodged within 3 years or 2 years, depending on whether the driver of the vehicle is identified. quite importantly to point out that if the driver of the other vehicle is unidentified and you are claiming on behalf of a minor child, it's then necessary to ensure that the claim is submitted within 2 years and summons has to be issued within 5 years. The Road Accident Fund has its own prescriptive provisions. So if the vehicle is identified, you can claim, if you're a minor, until 3 years after the age of majority. So if you're 6 years old when the collision occurs, you can then go on to claim for as long as 3 years after the age of 18. The same doesn't hold true with hit and run collisions. So it's quite important to note that if a minor child is involved in a collision where the driver is unidentified, they would have to claim within 2 years. And the summons would have to be issued within 5 years, irrespective. So that's quite important. In terms of heads of damages, like I said, you can only claim in respect of physical injury sustained. You can claim for your past and your future medical expenses. We will discuss the manner of proof a bit later. You can claim for future hospital, medical, and related costs. You can claim for past and future, I'm not sure if I mentioned past and future loss of income. And you have your general damages claim, which is a qualified claim. There are certain aspects you need to prove before claiming. And then in terms of loss of support and funeral expenses, you can claim funeral expenses and loss of support if a breadwinner is killed in a collision, their dependents are able to claim a loss of support as well. So that's just in terms of the type of damages. Once your claim is lodged with the Road Accident Fund, the Road Accident Fund has 120 days to investigate the claim. Once they have investigated the claim, and if they do not revert, one issues summons after that 120-day period. Quite important to point out is in our current culture, which is a very litigious one, I know of no attorneys that are settling without the issue of summons. We hope with the new CEO that will change. It seems that he is very positive to settling matters earlier. So one issues a summons, one runs through a lengthy litigation process, and then either settles by way of out-of-court settlement or goes to court and runs a trial. So that's basically it in terms of lodgement. And we will discuss the heads of damages in detail a bit later. I think what I'm going to do is I'm going to head over to my list and suggest that Josh comes in now, and she's going to deal with a couple of aspects in relation to the necessities of claiming.
Hi, everybody. Thank you so much, Marian and Conflict Dynamics, for hosting us. It's truly my pleasure and privilege to be here this morning. So as Lee said, that when you're lodging your RAF claim, you've got various heads of damages which are claimable. So the first heads of damage that I would deal with is the past hospital, medical, and related expenses. Under the heading of past medical and hospital expenses, you've obviously sustained an injury and you've sought medical attention. And in order to have that head of damage approved by the Road Accident Fund, you've got to submit all your accounts and vouchers relating to the specific treatment for the injury sustained. Now that is very important because your claim will be dismissed if you're going to lodge for example, a invoice or a statement for buying toiletries as opposed to inflammatories or anti-inflammatories or painkillers. And at the Road Accident Fund, when you assess a claim, you're looking at all the documentation together with vouchers that have been attached to your claim form. Sometimes claims are delayed or the fund is unable to conclude their investigation and look into or make an award in respect of past and hospital medical expenses purely because of the fact that the vouchers are not in order or they don't support the nature of an injury. So if you've had a whiplash injury and you're going to go and have a massage, they may dismiss that aspect. However, it's important to note that it again depends on the claims assessor handling the matter at the Road Accident Fund as to whether they're going to approve a massage or chiropractic treatment In those instances, it's very important to submit your medical reports or a motivation from your treating physiotherapist or chiropractor to support that claim. So with regards to past hospital and medical and related expenses, one has to submit all information. A related expense that may be claimable or may be approved, if the accident has rendered you incapable of going, for example, in the instance of a child, to continue school, and that child now needs to go to a special school, or certain things have to change, that remedial expense is claimable. And again, it will be approved provided the necessary documentation to support that claim has been submitted. With regards to future medical and related expenses, so future medical expenses is obviously set out in medical legal reports. And when you become injured, or you automatically, there could be, for example, I'll use a whiplash. So you may be compromised, and there may be sequelae from the accident, and it renders you needing ongoing treatment. So you'd have a medical legal expert like an orthopedic surgeon or a neurosurgeon to assess you. In that report, it sets out that you will require certain future treatment. So you may need further medical legal treatment in the form of physiotherapy, medication. You may need to go for MRIs, or you may need to change the structure of your home if you're compromised and you have a disability that will remain. All that is set out. Now, in setting that out, future medical expenses will then be calculated, and this is again left to the legal, not the legal experts, but the medical legal experts, the doctors. Attorneys are not in a position to determine what your future medicals will be. So experts are very important. And your related expenses there, again, if you compromised, you've become a paraplegic, your home needs to be adjusted, your workspace needs to be adjusted, those expenses are all claimable. The Road Accident Fund many years ago would allow that head of damage in the form of cash. But obviously that has changed, and the Road Accident Fund now issues a letter of undertaking. And your letter of undertaking allows all these expenses to be set out and claimed for future as it's set out there. So these, I know back in the day, Lee, and maybe you can just add on, those claims were also referred to an actuary to determine what the future values of that would be when they awarded cash portions. But obviously now with the undertaking, it's all set out in your letter of undertaking, it's noted, and it's registered with the Road Accident Fund's Undertakings Department, as well as possible case managers that may be allocated to assist on the matter. With regards to future medical expenses and the medical legals, there's another aspect that we need to look at, and that is the aspect of pre-existing conditions and comorbidities. Now, with a pre-existing condition, the rule is that you take your victim as you find them. And we refer to the talem qualem, or the thin egg skull rule, where if you have a pre-existing condition, for example, you might have osteoarthritis, or you might have spondylosis of the back, and you have a whiplash injury. The question is, how has the whiplash injury been aggravated, and to what extent has your pre-existing condition exacerbated your whiplash or your current situation? Again, that aspect is dealt with by a medical legal expert. And the importance of that is the Road Accident Fund will not compensate you for a pre-existing condition. But as your medical legal sets out that your pre-existing has been aggravated or has been exacerbated to a degree or a percentage, the Road Accident Fund will be liable for those medical expenses and other related expenses to help you cope in future. Your letter of undertaking, again, deals with all of this, and it is set out very clearly by the Road Accident Fund and by the attorneys in drafting and finalizing your settlement, mostly these days at the doors of court. So with regards to your medical expenses, it's very important, and also your future medical expenses, that the claim is properly investigated with the correct medico-legal experts, it's correctly quantified, and your pre-existing condition is noted. So to support that, the Road Accident Fund often will call upon your medical records, your past and your present, and your medical vouchers relating to treatment that was administered from the time of accident until the claim is settled is vital. The Road Accident Fund sometimes will make payments directly to the medical aid if you are covered by a medical aid, and medical aids often receive undertakings from attorneys or from the Road Accident Fund to ensure that those funds are paid back, so they avoid double compensation, to put it very simply. With regards to past loss of earnings, so you've been indisposed and you've had to not go to work, and as a result of that, you are allowed to claim past loss of income. And past loss of income, the documentation used to support that would be your salary slip, your employment contract, your IRP5, commission slips, a letter from your employer, and also, again, your medical doctor or the specialist who's been treating you will provide support to say that as a result of the injury, the person has been indisposed for a period of X number of days, months, or years in some instance, and thus the claim is quantified for past loss of earnings. The Road Accident Fund is actually very right in insisting that all documentation be in place. They often refer to get your SARS information and let's verify this. It's all normal, it's right. We cannot support claims that are not correctly proven. So again, the basis is that he who alleges must prove your claims. If you're setting it down in your claim form, you must support it with the correct vouchers. With regards to future loss of earnings, and Lee will deal with this again further on, all documentation relating to future medical expenses is set out, or loss of earnings is set out in your medical legal reports, your industrial psychologists, your occupational therapists, and ultimately your actuaries who do the total tally. With regards to funeral expenses, the Road Accident Fund will only pay for the actual funeral where it's the casket has been immersed into the ground, or a cremation. And again, the claim forms and the supporting documentation needs to be attached. So it will be your invoice from the funeral parlor, together with a medical report, a post-mortem if necessary, a death certificate, and obviously the claim in respect of the cost of a bus or a tent or food is disallowed by the Road Accident Fund, together with the cost of a tombstone. With regards to traditional treatments, in as far as your past medical expenses and possible future medical expenses, it can be argued and motivated, but again, it depends on who the claims assessor or the defendant attorney is in assessing that. In some instances, they have been approved, but in most instances, in my experience with the Road Accident Fund, they've been disallowed. With your funeral expenses, again, it's limited to the actual funeral and the cost of, let's call it disposing the deceased in the most dignified of manners. Again, your undertakings for future medical expenses are set out clearly and they are limited. However, if certain issues arise, I am sure that with sufficient medical support from doctors in the form of reports, that treatment will be allowed in terms of your undertaking, so long as it is accident related. With regards to loss of support, again, the breadwinner has passed on and all their proof of earnings will have to be submitted to the Road Accident Fund in the form of, again, salary slips, employment contracts, IRP5s, any commission statements. So you're getting the understanding now that it is extremely important and vital to ensure that your supporting documentation is 100% in order to enable the RAF to correctly assess your claim. Lee will now take on the aspect of future loss of income and earning capacity.
Maybe Lee, if you could also just address a question that has come up on the Q&A, and that is whether a hospital account needs to be submitted if the RAF has paid the service provider directly. Okay.
Right. Sure, I'm absolutely able to do that. So one wouldn't have to submit the account to the fund if it's already been claimed by the service provider themselves. However, it's quite important to note that a lot of these accounts are very, very specified, and they give a lot of information in terms of the nature of treatment rendered. So supportive accounts like that can be helpful in giving the fund an idea of exactly what the extent of the injury is. In fairness to the Road Accident Fund, and this is what Josh has given quite a bit of info on now, in fairness to the fund, you can't just expect the fund to pay. The more information that one gives the Road Accident Fund to prove the claim, the easier it is going to be for the Road Accident Fund to assess. And that goes all the way through. So do you have to attach that account? Absolutely not. But it may be helpful when you're addressing the personal claim of the injured party to assist the fund in seeing what treatment has been rendered. So if you're okay, Marion, I'll move onto the next head of damages, and I'm going to spend a bit of time on it, because with all the limitations that have been placed, on the claim process, future loss of income has really, really been, or it's become, the most contentious head of damages to claim. Post-2008, a cap was put on the claim for future loss of income, and at that time, it was said that a claim for loss of income was limited to 160,000 Rand a year. That total has been increased in line with inflation over the years, and I'll be completely honest, I don't have the figures sitting to hand at the moment, but it's significantly more than that now, but undoubtedly, it limits many, many claims. So that's the first thing in relation to a claim for future loss. But as Joshila said, one still has to prove the loss. So there's going to be salary slips, there's going to be tax returns, there's going to be a whole lot of documentation which needs to be given to the fund in order to prove that claim to start with. Your claim for future loss is very reliant on the opinion of your medico-legal experts. For example, if you have a client that sustained a traumatic brain injury, you're going to have a lot of input from your medico-legal experts. They may say to us that, well, the client's injuries are such that he's not going to reach his career ceiling that he would have pre-accident. He might have an early retirement. He may not even be able to work. But very often what happens with injuries is clients remain employable, but possibly not on the level they were prior, and definitely not to the extent that they would have been pre-accident. So their career ceiling gets lowered. We take all of this information from medico-legal experts. We do interview employers. We do need to give collateral evidence for the Road Accident Fund. But in terms of proof, it's absolutely crucial that the Road Accident Fund is given sufficient information to assess the extent of that loss. Remember as well, the Road Accident Fund is entitled to brief their own experts. I beg your pardon. The legislation says that the Road Accident Fund can request assessment of the claimant by their own experts. And in fact, they're entitled to repudiate the claim if the victim isn't prepared to undergo those medico-legal assessments. So that's quite important as well. What's very important with loss of income or future loss of income is contingencies. And it's one area that I feel is necessary for mediators to be familiar with. When I talk about contingency deductions in the context of loss of income, I talk about the risk factors. We have certain risk factors that everyone faces in life. For example, early death anyway, sickness or ill health, which is not related to the accidents, unforeseen circumstances, which may render a person less competitive or unable to work. So these risk factors are taken into account. Now, the older a person is and the more established they are in their career, the less of a risk there is, because they're set in their careers and they're pretty much going along doing their own thing towards retirement. If you have a younger person you have someone who's at the beginning of the career, they haven't really seen how they're going to fare in the workplace. No one really knows how they're going to do in the long term. An individual like that is going to have a significantly higher contingency deduction made on their total calculated loss. And the reason for that is fairly logical. Like I said, one just doesn't really know what's going to happen in the future. The closer a person gets to the age of retirement, the lower the contingency deduction becomes because they are so close to the age of retirement. So with loss, the standard contingency deduction that's applied in this regard is 0.5% per year. So if you have a 20-year-old, or let's say a 30-year-old, who is now injured, if one looked at a contingency deduction, bearing in mind the retirement age would be 65, you would take that 35-year working life divided by 2, and hopefully, if I'm right on my maths, it would be 17.5%. So that's how we calculate the contingency deductions on a pre-morbid earning scenario. So we'll calculate our loss of earnings actuarially, and we will look at that total and we'll apply the contingency deduction. In respect of loss thereafter, we now want to calculate what the person's loss of capacity is post-accident. Post-accident, what we often do, because a person may no longer be an equal competitor in the open labor market, they may have been put into sheltered employment because of their injuries, and they can't compete with their able-bodied counterparts. And because of that, in the post-morbid or the post-accident scenario on our calculation, we very often look at increasing that contingency deduction to cater for the fact that they are even more vulnerable than they were before. An understanding of these contingency deductions, or at least the maths behind it, I honestly believe is crucial in order to successfully mediate an RAF matter. Simply that it gives a good understanding of what the parties are doing. Attorneys by nature are quite an impatient bunch, or most of the ones I know, and they generally have a good idea of exactly what they wanted to look at. So when they come into a mediation, they pretty much know what the issues are. So you might find that, in respect to future loss, they'll say, right, well, we're prepared to look at the scenarios that are set out by the experts, but it then becomes a negotiation on the contingency deductions. So like I said, 0.5% per year for the amount of working life that the individual has. And thereafter, in the post-accident scenario, on our post-accident calculation of loss, we look at raising that contingency deduction if there is significant vulnerability. You might find that a person post-accident is put into a much simpler position, and that their position, they're not particularly vulnerable because they're able to cope with that level of demand in the workplace. But those contingency deductions are quite important. Again, just going back to proof, in a court situation, it's often necessary to call the employers to court. The employers of the accident victim, both at the time of the collision and before and after. So one tries to look at a full work history. And the collateral evidence of those employers is incredibly important in determining what that party's long-term outcome is going to be. And again, one can't just give a broad overview and say, right, well, if I'm a doctor, this is where I'm going to go. Or if I am a municipality worker, this is where I'm going to go. One has to look at what their performance was in the workplace beforehand. I've had matters where the employer has turned around to me and said, you know what? Yes, he's been in an accident, and yes, he's not working as effectively. But the reality is that he wasn't a particularly good worker before the accident. Now, something like that is also it has to be taken into account as well. So in terms of future loss, generally our industrial psychologist will take all the other medico-legal evidence. Industrial psychologists are crucial. They will give us the career paths, both before and after the accident. So they will take all the other reports. It will be your occupational therapists, clinical psychologists, psychiatrists, neurosurgeons. I'm not going to mention them all, there are too many to mention, but they will take all of those reports. They will then plot out what they believe to be the most probable scenario in terms of career path, both pre-accident and post-accident. And the industrial psychologist report is really, really a lovely one because it also summarizes most of the medico-legal evidence, and you can really get a good idea of exactly what the claim is about looking at the industrial psychologist reports. So that's future loss. You must let me know if I'm starting to run into time problems. General damages is the next issue I'm going to deal with. Now, general damages used to be unlimited. Now you have to sustain what they call a serious injury in order to qualify for a claim for general damages. General damages is the serious definition is a legislative definition. It's not a dictionary definition. So what the legislation says is that if a person has sustained 30% or more whole person impairment, or has sustained or suffered significant long-term impairment, and we deal with those aspects by way of a narrative test, only in that event are they entitled to claim. We submit an RAF4 report to justify the claim for general damages, and thereafter the Road Accident Fund is entitled to either accept that report, reject it, or refer an accident victim to their own expert to assess the seriousness of the injury. If they reject the report, we run through quite a lengthy process with the Health Professions Council of South Africa, who is tasked to make a finding on seriousness. They will convene a tribunal. They will then assess whether the injury is serious or not. And while it is often said that their decision is final and binding, this is not necessarily the case. One can challenge the finding of the HPCSA in court. Our courts to date have not been prepared to make a finding on seriousness because Regulation 3 says that the decision is final and binding. But you can bring an application to court on the basis of the Promotion of Administrative Justice Act and set out the basis of the challenge, which would be unfair administrative action. I myself have challenged decisions before and have successfully had a reassessment by the HPCSA. Not always successfully. I sometimes get two non-serious findings. Sometimes one wonders, am I wrong or is the HPCSA wrong? I'm sure they will claim they're right, and I would suggest sometimes they're wrong. But general damages is not a head of damages that is automatically claimable. One runs through that tribunal process, and the assessment process and the two different ones relate to the American Medical Association guides. So whole person impairments, or the 30% thereof, is determined on an American model in terms of whole person impairments. My issue with that is I actually find it a pretty meaningless exercise because one still falls back onto the narrative test. So if an accident victim has not qualified for the 30% whole person impairment, one would still look in terms of other issues, for example, a serious loss of body function, or serious long-term behavioral problems. These are other issues we look at, including permanent disfigurement. So those two aspects of the way in which seriousness is assessed. Thereafter, once we know that the general damages claim is there, we look towards previous court decisions. So the way we assess the figure for general damages is we look at what courts have awarded in the past to victims who have sustained similar injuries. We've got a huge, big volume of case law. It's called Corbett and Buchanan. In later years now, it's called Corbett and Honey as the volumes have gone on. And we literally look at previous court decisions to see what sort of awards have been made in respect of general damages to other victims who've sustained similar injuries. The last thing in this segment I want to talk about is causation and proof of injuries. It is not essential to have injuries cited on hospital records in order to successfully prove a claim. I think what's important to note is when a client is taken to a casualty department, particularly in our provincial healthcare sector, one has to bear in mind that these guys are overwhelmed. They're dealing with hundreds of victims, and sometimes things do slip by them. That is on the one side of the scale. On the other side of the scale is the poor Road Accident Fund, who has to be given proof of those injuries. Otherwise, the risk is people fabricating injuries. I've had clients tell me before, particularly one in the past, who said, oh, he's got bad facial injuries as a result of a car running him over. It actually turned out that he'd been assaulted and he'd been thrown onto the car. So the Road Accident Fund, in fairness, needs to be given that proof. And hospital records, where available, I do believe should be given to the fund. But in terms of causation, one does have to prove that the injuries have caused the long-term problems that the victim sits with. Joshila mentioned earlier on comorbidities and pre-existing conditions. A victim may sustain an injury which doesn't have a bad outcome, but there's a pre-existing condition which has rendered the individual impaired to whatever extent that may be. So one does have to prove a causal link between the injuries that have been sustained and the long-term problems that the accident victim sits with. So that's in terms of causation and proof of injuries. And I'm sure we can deal with any questions afterwards if there are any, or if you want to deal with them now, Marion, I'm happy to. The next sector Joshina is going to deal with.
Just to give you a sense of what the questions are that are coming through, Lee, and maybe you can address them later. I mean, there are questions about who is the accepted source for the size of the contingency. So who would be the right person to make the decision on the size of the contingency? There've been a couple of questions around that.
Should I answer now as we go, or?
Let's.
Okay. So contingency deductions are a matter of negotiation between the parties. When you get to court in a court situation, the attorneys and advocates will debate those contingencies. If you're dealing with the road accident fund directly, the accident victim's attorney generally, or if they're acting unassisted, they would negotiate with the road accident fund. And it really does become a matter for negotiation. That's why I've said it's so important just to be familiar with the principles relating to contingencies. So yes, it can be the prerogative of the court. The court can make a finding on contingencies if loss of income is not settled. But otherwise, the parties negotiate those contingencies.
So that would be an area where a mediator could assist in that negotiation process, really.
Absolutely. And I can tell you now that when it comes to the mediation space, it's going to be one of the areas that have the most focus.
Okay, great. On to Joshila, who's going to be dealing with the next area. I'm just concerned we get through the time. There are a number of questions. I encourage you all just to keep them for the Q&A session after the input. Thank you. Keep posting them. We'll get to them.
Okay.
Thanks, Joshila.
So I'm going to talk now a bit about curatorship and the incapacity to act. You get three types of curators, which is the curator ad litem, which is a curator for litigation. The curator litigates on behalf of the patient, and in these instances, a person probably would have a very serious accident or an injury, and as a result of same, the medical legal expert will advise that the person is incapable of making good decisions, and as such requires a curator ad litem. That is determined on a medico-legal basis. With regards to the curator bonus, that is a curator for goods, and this curator protects the patient's financial and propriety interest as far as needs be. And then you also get the curator ad personam, which is if a patient's daily living needs are compromised and they need to be in a care facility, a curator ad personam can be appointed. So what happens is the application for a curator is brought about somewhere in between the RAF process, where it is then determined that the party is now incapacitated and does not have the necessary capacity to act. The application is made, the costs of that application is, and the initiation of a trust, if the court so finds, is obviously set out in the undertaking. Now, I just want to go back a few steps. When the RAF determines a claim, they determine in the form of merits and quantum. And if on the merits they determine that there is an apportionment of damages and the party has contributed towards the accident, they would apportion the claim, and that impacts the quantum. So, for example, if a person who is placed under curatorship as a result of a very serious brain injury in this instance, there would be a apportionment on the undertaking where the fund will only be responsible for damages, for instance, up to 70% if they've deducted a 30% apportionment on the RAF claim. So the process for curatorship, we all know, is that you approach a high court together with the necessary medico-legals, And in Johannesburg specifically, I think there are a few attorneys who take on the responsibility of acting as the curator in this instance. With regards to the capital and the costs, the RAF will make an award in terms of a capital which comprises of your expenses, your cash component, and obviously there's the undertaking, which is not obviously cash related, but your cost in respect of your payment for your medico-legal experts, your attorney costs, which is generally an agreed cost, and also your expert fees, your travel costs, as well as the cost of counsel. So in this instance, again, these costs are generally taxed. The RAF will normally make that payment after they've settled the capital. I think Lee can take us through a bit about how the RAF has recently been making payments in respect of the capital and the costs.
Sorry about that. Let me unmute myself. So basically, let's talk a bit about litigation and the RAF. In the last couple of decades, the fund has moved towards functioning in a very litigious culture. And I think we sit in a position now where our courts are so crowded out with road accident fund matters that we have to look at another means of resolving these disputes. There's been a very much an us and them type of dynamic that's developed over the years. In terms of, yes?
Sorry, just before you go on to the dynamic, the us and them dynamic, can you give us a sense of that crowding, that sort of overcrowding that you speak of? What do the numbers look like in terms of those cases in the courts?
Okay. So if one looks, and I'm going to look at Gauteng courts because I'm in Gauteng, in Pretoria or Joburg, there's often over 100 matters a day, maybe even 180 set down in our courts. One must bear in mind, these are not only road accident fund matters, these are all litigated matters in that court, whether it's matrimonial matters, family law matters, whether it's banking matters, doesn't matter. This is a total tally of matters per day. On any given day, if you go and look at that court roll, you will find, I would wager a guess, 85% of matters are RAF matters. Now, what's happening more than the crowding out and the number of matters, the sheer numbers, is the availability of the judiciary. There are only a finite number of judges available. So what's happening very often is you get to court, you've waited your 2 years plus to have your day in court, and when the matters are allocated, there are no judges to hear the matter. So what's happening is these matters are postponing, and when they postpone due to non-availability, you're waiting for another 2 years. I have in recent years had matters that have been postponed previously. I've got to court a second time, and my matter's postponing again. So now my client's waiting another 2 years. The judges try to help where they can. I mean, I don't want to knock the judiciary, but the reality is the courts are so unbelievably crowded out that I honestly believe there is no other way. And look, the positive is that the new CEO has taken a policy decision towards mediation. I think it's absolutely fantastic. It's going to be a lifeboat or a lifeline.
Mm-hmm. Yeah, those numbers are extremely intimidating, aren't they? They really put it into context. If you 85% of them on each day are RAF matters.
Don't hold me to the percentage. It might be a bit more, it might be a bit less, but I can tell you that the vast majority of matters on those court rolls are RAF matters.
Yeah, we recently had a presentation by Judge Sutherland, and he gave us similar numbers, so a similar indication. Let's not get stuck on the numbers.
Yeah, no, sure.
Sorry to interrupt you. If you'd like to go back to the kind of us-them dynamic.
Yes, I was just talking about the us and them dynamic, and it's been there, and I readily admit over the years I've been guilty of it as well. An element of distrust has come between the Road Accident Fund and particularly plaintiff attorneys and defendant attorneys. I'm not laying blame anywhere. There are the most amazing RAF attorneys and individuals at the fund, and there are some atrocious plaintiff attorneys. The same holds true, so vice versa. But the reality is this distrust is there. I think what mediation will do is it will shift And there needs to be a move back to looking at the accident victim and saying, look, this is who we're meant to be compensating. We need to stop fighting. We need to move towards a point where we can look at fair, reasonable, and just compensation. And I think mediation is going to be the vehicle that takes that forward. We've looked at, if I could just mention also, Rule 41A, just let's incorporate that together. Mediation has been in the court system to a greater or lesser extent over the years. It's mentioned in Rule 47. Mediation has been hugely successful, and you are better placed to talk about that than me, Marion. But what's been so lovely over the last while, and it's not very long, is Rule 41A now gives us an opportunity to push a defendant, or for a defendant to push a plaintiff into the mediation space. I brought an application earlier in the year, and I've tried to circulate that order quite widely because I think it's useful to everyone, I brought an application to court, and it makes no mention of Rule 41A, saying, look, here's my clients. All the medico-legal reports are in. All the experts have compiled joint minutes. We've had a trial date. There was no judge available. And my client is now sitting waiting a year and a half further for his damages. And I say to the court, mediation is cheap and cost-effective. It's a much cheaper option than court. We need to look at it. The rights of the victim need to be considered here. And I was over the moon when the court ordered mediation. I gave I gave an alternative in my prayers, and I said the court must please order either mediation or order the defendant to consider mediation. The matter hasn't moved forward since then, but it was granted. That order was granted a week or two before Rule 41A was even implemented. So in the mediation space, I do honestly believe that it's going to be absolutely fantastic. I think what will be important in the beginning stages of mediation is definitely a bit of transformative stuff. Just to get the parties together and say, look, we need to look at the victim. We need to put the distrust aside. We need to put, all of our differences aside going forward. And don't get me wrong, this is not how all attorneys or claims handlers operate, not at all. But if one has to look holistically, that's the way it is. I remember a very wise attorney called Susan Nurek, probably 15 years ago, said to me, Lee, you cannot look at how you're handling a matter and assume that every other plaintiff attorney is handling the matter in the same way. And it holds true for road accident fund claims handlers and defendants and plaintiff attorneys. So it's such an unbelievably exciting time in our law, particularly on the personal injury front, to start to try and move away from this litigation. You get to court. I'm going to talk a bit about capital and costs. I'm not sure, I don't think Joshila addressed that too significantly. So what I'd like to do is look at that. The costs of a court trial. You've got counsel who will charge a significant day fee. You've got your experts who have to come to court. The court taxing master does not allow all those reservation fees of the experts. So you've got your clients who are at court, some of them are out of town. You've got your experts at court. You've got the advocates at court. You've got the attorneys at court. And it's an absolutely absurd expenditure in circumstances where these matters are settling on the steps of courts. So we're incurring all of these costs. We've got everyone there, and 90% of the matters are settling on the steps of court anyway. So just to talk about capital and costs quickly, the Road Accident Fund makes two payments. They make a capital payment, which is your actual damages. And your actual damages would be calculated in terms of those different heads of damages. Attorneys generally deduct their fee from that capital figure, and they also deduct all the disbursements, because remember, attorneys are generally covering all the disbursements all the way through to finalization of the action, and they don't charge a fee until the end of the action. So they generally take all of that off the capital of the claim, but the Road Accident Fund makes a second cost contribution. So there's a capital payment and there's a cost contribution. And in that cost contribution, it's normally paid on a tariff scale, party and party scale. It's quite a low tariff, and I always use the example of medical costs, because for me it's an easy way to explain it. You've got provincial healthcare rates, you've got medical aid rates, and you've got private rates. I would pitch party and party costs as somewhere between provincial healthcare and medical aid rates, just in terms of the tariff. There might be experts or attorneys or colleagues out there who agree with me, but that's always where I've seen it's pitched. So they will pay that party cost contribution. They pay the cost of medico-legal reporting almost entirely. It's very seldom I find a taxing master that doesn't give medico-legal costs. What they don't cover in full, though, is the preparation and reservation fees of the experts. So you've got your experts preparing a couple of hours, then they're going to court and they reserve their day and they're losing a day, so they charge for their reservation as well. Those costs are a bit of a killer when it comes to taxing your bill of costs. So those largely the victim ends up footing the bill for. And, you know, advocate fees, a big portion of advocate fees is covered. I most certainly don't begrudge the advocate their fees at all. I mean, they're performing a service that needs to be performed. But if one could put this into the mediation space, and you have either a representative from the Road Accident Fund coming or an attorney from the Road Accident Fund, you've got the plaintiff attorney and you've got the mediator, you know, there's every possibility that you could cut those costs out, especially the expert costs. The reports are there in paper, and we're now arguing over the evidence. You've often got two expert reports where, I must be honest, it's sometimes difficult to believe they're talking about the same person. You know, there are wonderful experts on both sides, plaintiff and defendant, but I have seen some also awful reports. So depending, but you know, if you're dealing with an experienced attorney on both sides and you're dealing with a mediator who is familiar broadly with the Road Accident Fund claim process, honestly, it's going to be, I can't tell you how excited I am about it. It's going to be brilliant. So I think that brings us to the end of the content. And I see, apologies to everyone in this webinar, my typing is atrocious. I might type fast, but I don't type accurately. So I haven't really answered too much. But we can step into the Q&A and possibly deal with the questions that have arisen.
Yeah, that'll be great.
I'd like to go back to one thing. Back in the day, when the Road Accident Fund came into being and took over from the so-called MMF and the insurance houses, a lot of matters were settled in this manner, in the sense that there was a meeting between the plaintiff attorney and the defendant attorney and the Road Accident Fund representative who had a mandate. And in most instances, it was attorneys who were no longer practicing on the roll or were non-practicing. And a lot of matters got settled very quickly. And the turnaround time and the cost management thereof was remarkable. So going into the mediation space and going into a sense of the way the fund used to be, in the sense that they turned out matters a lot quicker and they got the purpose of the act and they got the compensation out to the injured individuals and the people that it was intended for, was a lot more smoother and a lot more easier to manage than the current situation of litigation. And I say this with the utmost of respect to my colleagues, be it at the fund or the defendant attorneys and plaintiff attorneys. It doesn't serve the purpose of the act. And if mediation doesn't come in, or we don't find an alternative solution to manage the current backlogs and the current system that is used to settle RAF matters, we won't be able to continue much into the future. We'll still have the backlog. You know, I mean, Lee was advising recently that the fund now puts you into a slot to pay out your damages. You know, attorneys are receiving plaintiff contributions in portions, and that's not the way it should be. So I'm hoping that going forward, you know, that the RAF and plaintiff attorneys and defendant attorneys would be able to work together for the true purpose of what the Act is set to do, to compensate victims who have been injured. And I think mediators have a remarkable role to play in this.
I'm going to just interject there, what Josh said, just to clarify. Yes, you know, the Road Accident Fund, because of its cash flow problems, we're all aware of them. Most attorneys have entered into payment arrangements. And I think the bulk of those are dealing with a 5-month turnaround time. So, for example, if a firm of attorneys is owed 150 million or 100 million, let's use an easy figure, And the fund will look at it and say, right, these are the amount of claims that are requested on our payment system. It totals 100 million. We're going to pay that to you over 5 months. So they'll pay 20 million a month. You get to the end of the 5 months, and you then start readdressing. And the fund says, okay, well, let's see what the figure is currently. Right, it's only 80,000 or 80 million. We're now going to look at that 5-month plan. So they have put in protocols. So they're not paying claims specifically in portions, but they're trying to allocate their funds as best as they can. Of course, there are still attorneys who are issuing writs. It does, I suppose it does give preference to their clients, but in this, in where we're currently operating, I mean, even the sheriffs are not able to attach, so there has to be, there has to be a move towards working together.
So, Keith Robinson, to answer your question, it was between 1997 and 2001 that we followed this model under the guidance of the then Ms. Delia de Vries, who had managed the R1 million claim section, as they called it back in the day, where they dealt with claims where there was significant impairment. And that was, the litigation occurred, but in a much more structured and a much more mediated approach.
Okay, thank you. Lee and Josh have obviously got view of the chat function and the questions, so they've been addressing some of your questions as we go. I'd just like, there's one question that has not been responded to, and it was raised quite a lot earlier, and I just think if we could go back, I mean, we're getting very excited about the whole area of how to rectify the situation and mediation, but there was just a technical question that Rajashri raised much earlier, and that is just about if the claimant in a matter is a business owner whose salary is who takes out a limited salary from the business and invests a lot in the business, is there an alternative submission for proof of earnings except for the salary slips and the likes?
The financials. Okay, you go. It's cool.
I tell you where I'm going to go, because we deal with it a lot, in the litigation space. So absolutely, remember, one has to look, particularly with the individuals that are self-employed. Yes, where a lot of money is put into a business to invest with the view that the business will grow in the long term. These are definitely factors that are taken into account. We sometimes use accountants, for example, to assess the health and well-being of a business and to make a future forecast of where that business is going to go. So we definitely do. You don't earnings as per tax returns or financials. We would take that into account, particularly with a young business owner, where you've got that big contingency deduction because the guy's young and we don't know where the business is going. But most certainly one does take those factors into account, yes.
So the documents that you would need would obviously be your audited financial statements, and then you could get in an accountant to do a forensic report and do an analysis into the future.
Okay, great. Thank you for that answer. The other questions that are still open are the issues around mediation. Felicity asks the question, Lee, you made the comment that that mediators would need to have an understanding of how the RAF functions. Does this necessarily mean that they need medical expertise as well as mediators?
From my perspective, no, Marion. Look, I think there are useful contributors everywhere. Obviously, a medico-legal expert who is in the field and has a good understanding of the RAF process, will probably find the mediation process slightly easier. But I don't think that's absolutely essential. I think what's essential is to understand the basic principle, understand the heads of damages that are claimable. A medico-legal expert will be great on assessment of injuries and looking at future treatments. But, one looks at merits as well. One has to look at the liability of aspects of the claim, whose fault the accident is. I think I did launch into quantum quite quickly. But one also looks, and sometimes the liability aspect of the claim is in dispute as well. So I think at the very least, and I'm not saying that one has to go and now study road accident fund compensation at all, but a good overview of what the fund is, what's claimable, and how those heads of damage is approved, I think would be incredibly helpful in the mediation space.
Mm-hmm. Yes, and certainly, I mean, what's become clear to me today as a mediator is that this is a space that one will have to understand, and this is a good start to just getting to understand what is involved. So thanks for that. The other comment related to mediation specifically, and I know there are some of our attendees who have questions that are still outstanding, so I am going to try to get to all of them. We do still have a little time left. But the other question that is raised is whether you could make available the relevant order you were speaking about that you made or that you were successful in before Rule 41A came into place. Would you be happy to have us distribute that?
Marion, what I would like to, I do have privacy concerns, even though it's a public document, but I don't mind distributing it all just to take the name of the plaintiff and the case number out. But I can tell you this, and it's not to say my application is perfect. It was drafted by me. I stand here and give waivers and indemnities about people using it. But to be quite honest, I think that it's so important to get into the mediation space. I would put out to the attendees that if there's anyone who wants a copy of the order, you are welcome to distribute it, Marion, once the name of the plaintiff and case number has been removed. But I'm happy to give the order and the application. They can have my application as well with absolute pleasure.
No, thank you very much. Thanks. And that's just Jan asked that question, so we've dealt with that. The other issue, just to raise, Talia raised some questions about the loss of future earnings and how post-morbid contingencies are applied. Could you go back to that? I mean, we were dealing with that much earlier. Lee, you dealt with that, I think.
Yeah, I can. I saw that question. I can't seem to find a way I couldn't find a way to type the answers. I only saw a little microphone, and then I felt I'd be interrupting, so I didn't. Hi there, Talia. I hope you're well. Yeah, in terms of contingency deductions, I hear what Talia is saying, and that you have different types of ways that you're going to calculate. Sometimes you have a total loss of income, and sometimes you have a situation where the victim has retained some residual earning capacity. But just bear in mind that even where an individual has retained that residual earning capacity, and I'm going to go to the bottom of the earnings rungs by looking at, for example, a manual laborer. If you have a manual laborer who is still able to work, let's say he is able to work and he gets tired a bit quicker, and he maybe has a bit of a limp, but he's still able to work. There in the residual capacity, even though he's still able to work, he's not an equal competitor in the open labor market. He can't compete with his fully able-bodied counterparts. If he has to go for an interview with 100 other very able-bodied, healthy people with no impairments, he's going to be on the back foot. So even if there is a loss of residual capacity, I'm still probably, if appropriate, going to apply a higher post-morbid contingency deduction. But that is not always the case. Like I said, you can have a situation where, let's say we've got someone who's a secretary, and post-morbidly, they're just not able, from a cognitive perspective, to deal with the secretarial demands of the job. We now shift them into a receptionist's job, and they're able to deal with the demands of a receptionist. And if that is the case, and they're doing well, and there's good workplace feedback, and there's no reason to suspect that she would have problems with that, I might even consider not applying a higher post-morbid contingency deduction. It really does depend on the circumstances of each individual case. Talia, I hope that answers you. If it doesn't, let me know.
Thanks for that. There are clearly a number of experts that have joined the webinar as well. And maybe we can just speak a bit about, there have been questions about, okay, sorry, just before we move on, Talia has asked, what about the total loss of earnings?
Maybe she could just give me another line there. I'm not sure what she means in respect of total loss. One must also remember just the capping. And it's not necessarily relevant to Talia, but that the loss of income claim is capped. So if someone earns significantly more than the cap, their earnings are going to be kept in line with the maximum claimable under the legislation.
And
Okay,
Josh,
so the total loss is if someone is unemployable. You know, there, Talia, I would use a standard 0.5% a year. However, if you have someone who's got a pre-morbid condition or some sort of pre-existing injury, ailment, disease, which is going to possibly would have affected their capacity going forward, my contingency deduction on the total loss, you know, I might accept a higher contingency deduction, because remember, then you're just dealing with a total pre-morbid figure. So the starting point for me would be the standard 0.5% a year. If the person is healthy and there are no other factors, comorbidities, or pre-existing conditions which apply, I'm probably going to look at a standard 0.5% a year. But if there are other factors which become relevant, in fairness, you know, to the road accident fund, those have to be catered for, and that would be then be catered for on the pre-morbid scenario, you know, by making a bigger deduction than one would otherwise on the 0.5% a year. I hope that answers the question.
Great, thank you. I'm sure it does. We've spent a lot of time on that issue. Just going on to experts then. We've clearly got a number of experts joining the webinar, and you speak about the reports, and it sounds like, you know, there are a lot of reports required in order to inform these negotiations. What is your sense about the role of those experts going forward?
I'm going to say, and I don't, just, sorry, Josh, for interrupting, but just on a practical level in terms of the litigation space, I think one has to bear in mind that and I'm sorry to say it, I might get some flack for saying this, but the distrust in respect of the experts seems to have pervaded there as well. And the reason I say this, and don't get me wrong, I know the most amazing plaintiff and defendant experts. You do find often that experts do more plaintiff work or more defendant work, and some do both, and that's also excellent. But, you know, you do sometimes find such a huge disparity between what the expert appointed by the fund says and what the expert appointed by the plaintiff says. It would be absolutely wonderful if we could reach a point where we could look at appointing joint experts. I mean, it would limit the costs of the fund. The fund is paying for those reports. So, you know, my sense of that is to say, yes, that it would be wonderful to find experts who are acceptable to both the fund and the accident victim moving forward. Experts play an unbelievably important role. And, you know, the experts I work with, I have the greatest respect for. They spend hours assessing. So I think it comes down to the expertise of the medico-legal expert themselves. You have a lot of young experts coming into the system. I know brilliant younger experts, and I know some terrible older ones. Again, there, you know, whether you're good or bad, it's across the board. But it is important for the experts that are doing the medico-legal work to understand their role in assisting either the mediator or the... And it's very important to stress that you are not an expert of the plaintiff or defendant. You are an expert of the court, and you are tasked to assist either the court or the mediator in facilitating mediation. Mediator is not going to make a finding, but, you know, the role, it has to be there. You're there to assist in assessing the action reasonably.
Great, thank you. A couple of other issues that have come up. You've explained very clearly that this is a very specific role, and it's a role the courts currently and the mediator hopefully going forward will be assisting the fund to distribute payments effectively, claims, according to very clear guidelines, it seems to me. Susan Verhoef has asked, do you think there's any chance of non-monetary aspects coming into mediation settlements?
No.
Non-monetary aspects in what regard?
Well, I think probably just knowing where Susan comes from the medico-legal space specifically, The question is, in the medico-legal environment, there's often a high value placed on explanations or apologies being given when you're dealing with, the medical practitioners involved and the patients, effectively. Whereas in this instance, you're doing a job really for a fund that is paying out. So, I mean, from my perspective, it doesn't seem as if there's as great an opportunity for those conversations to happen during a mediation in terms of apologies or explanations, because you don't actually have the person who was driving the vehicle in the mediation.
No, I don't think there's going to, I think the restorative part of the entire process is to ensure that there's a settlement and to bring about a speedy settlement, as opposed to a protracted court process that is not only frustrating to plaintiffs, but also the claimant as well. And obviously the medical legal experts, because, in as much as the plaintiff attorneys are funding it, there's also agreements in place to say that, some funds are some experts are paid 100% upfront, some experts have to wait for their money. So from a monetary perspective, I personally don't think it's going to be the intent and the purpose of the RAF at this point in time to say that, we need to go in there and take away monetary components. No, the process of mediation is going to be to settle the disputes and to bring the parties to an agreement. It's not the mediator's role to make a final agreement or a settlement. The role of the mediator is to mediate, to understand or to allow the parties to understand what the issues in dispute are and to bring about a formative settlement. The settlement is not going to be concluded at the mediated day. A settlement will be drafted. It will be taken back to either the plaintiff's attorney and the fund's attorney, if there is one, or in this instance, I don't think there'll be one, but they'll be considered, and thereafter, I think it will go to a point where it's made an order of court. But I don't think the mediation heard on a specific day is going to deal with that.
Can I just give a bit more input there, because I'm not sure if Susan was possibly referring to the dynamic between the fund and the claimant, as opposed to, for example, a medical negligence matter where you've got the victim who is feeling very, very hard done by, and he's now coming to contact with the doctor who did this to them. As opposed to the road accident fund's situation where you're dealing with an insurer. So you're not dealing directly with the wrongdoer, as opposed to, a medical negligence matter where you are dealing with the wrongdoer. So I do think that, in that space, that emotional component wouldn't be there. But I do think just in the beginning stages, and even if it's in the opening stages of mediation, just to encourage, dialogue regarding why we're there. And we're there to compensate the victim. We're not there to beg your pardon, in terms of one-upmanship or to show who can pay the least or who can get the fund to pay the most. We're there for reasonable compensation. So that trust needs to be built up. So when I talk about it, it's more between the road accident fund and possibly the victim's representatives, which wouldn't be there in necessarily a matter like a medical negligence matter.
Yeah, good. That puts it in perspective. Thank you. Good. We're heading towards the kind of end of the period. I'm just going to give Lee and Joshila an opportunity to kind of wrap up in terms of all these issues, and then I'll deal with a little bit of housekeeping in terms of mediation and panels and how that operates. So, Joshila, would you like to start by just doing a little wrap up?
Oh, well, once again, I'd like to thank you for this incredible opportunity. I do believe that mediation is going to take us into an entirely different practice profession, if you want to call it that. Lee says that we're sitting on the cusp of mediation, and yes, we are. We've been speaking about this for just over 20 years, Lee and I, and I think the time is right. I think we, especially post-COVID, we're moving into an era or a situation where things will never be the same again. And I think with the fund being in dire need of resources, we're going to have to find an alternative to manage road accident fund matters. And I'm confident, having worked at the RAF and in plaintiff practice, and in running my own practice in recent times, that mediation is the correct thing to do. It's something that is happening worldwide. It's a speedy process, it's a cost-effective process, and it's sustainable in the long term. Thank you.
Thanks, Joshila. Lee, over to you.
Yeah, Dan, thank you so much for having me here. The one thing I will say, I'm always open to engagement. I may have, these are my perspectives. There may be people who don't agree with them. I'm always happy to engage offline. You're more than welcome to give my email address out. If there's anything that, anyone wants clarity on, I'm more than happy to, to deal with those questions. But I echo Joshila's sentiments. I do believe we're on the cusp. We all want it to be successful. In order for it to be successful, we definitely need guidance from people like you, in terms of facilitating the mediation process competently and ably. And that's pretty much. So thank you so much for having me. And I'm available offline per email if necessary.
Great, thank you very much, Lee. Just over to what is available and what's happening in the mediation space and our space specifically. I think I just want to reiterate what I said at the beginning of the session, and that is that mediation can happen in a number of ways. And we've seen in the South African context that it can be very successful in certain statutory environments. It's very successful when it's privately run, but there isn't really a preference. The RAF is going to have to think about what works in that environment specifically and what their constraints are or resources are in order to really get this mediation process working optimally for the fund and the claimants on the fund. From conflict dynamics situation, we'll do anything we can to assist with that. And we have made ourselves available on the pilot I referred to earlier, the SUMLA pilot, which hopefully will kick off soon. I know that Dr. Edeling is speaking with the RAF about a memorandum of understanding. So if there are mediators out there who are experienced and would like to be part of that pilot, SUMLA mediators, accredited mediators, and conflict dynamics accredited mediators can be part of that pilot program to work out how one can best do it, really. So please let us know if you're interested in that. We did send an invitation to all our accredited mediators about a month ago, I guess. So go and scratch in your inboxes. I'm sure it's still there. I'll mediate, so getting onto some of that marketing that I spoke about earlier. What we can really do is we can make sure that our mediators are well trained to local and international standards. We offer an opportunity to get experience by being on our panel. In order to be on the panel, you have to have some experience, just because those are the DISAC criteria, which DISAC is the organization that manages standards for mediators in South Africa. Our mediators have insurance, so that's another thing that's important, and we comply with those DISAC codes of conduct and discipline effectively. What we can also do from the conflict dynamics perspective is we can train lawyers in how to represent their clients in mediation. If things do move this way and mediation becomes standard practice at the RAF, lawyers will need to think about how they incorporate that in terms of how they advise their clients. So there's definitely a role we can play to assist lawyers on just taking this into the realm of what they offer their clients. And then finally, we train mediators. And we're very excited about the fact that we're training our first group of mediators online at the end of next week. So that's going to be a big experience. But we continue to train mediators, and please just look at our website for dates of courses coming up this year. and we hope that we'll get involved in training RAF mediators as well, down the line. So thank you very much for participating. We're getting to the point of our time being up. Again, Lee and Joshila, thank you for fantastic input, giving us a real sense of what the RAF is all about and how potentially mediators could get involved there. Thank you for the time in preparing this. What I can also say is Lee has put together a fantastic document that outlines this information, and we'll be making that available on our website after this session, as well as the recording or an edited recording of the session, so that you can go back and check some of the input and the discussions that happened. Lee's also forwarded us all the RAF forms, and it might be useful for you to just take a look at those forms so that you know exactly what is required from the RAF. Familiarize yourself with those, and we'll put those onto our website as well, just for your reference. So yes, thank you to Craig in the background, and we hope to see you all on a future webinar, and we certainly hope to see you all involved in mediating in some way, or advising clients in some way to mediate around RAF matters. So thank you very much, and goodbye.